the section of Civil Rights and Social Justice and the Center for Human Rights. This panel is the second in the series of webinars that we are having addressing HIV legal issues. We are planning additional programming on a variety of issues, so please visit our website for any updates. So during today's program, we encourage you to ask questions of our panelists through the question and answer, not through the chat. If you do not see the controls, please ensure your screen is not idle. We will address questions at the end of the panel. We will be sharing a recording of this program to everyone who has registered so that you can share it widely with your networks. And that brings us to today's program, which we are thrilled to have several experts joining us today. David Wilkins is the Director of Immigration and LGBTQ HIV plus advocacy at Staten Island Legal Services. Previously, Mr. Wilkins worked as an asylum officer in the U.S. Citizenship and Immigration Services. He also served as a staff attorney and Immigrant Justice Corps Justice Fellow at Central American Legal Services. Tess Feldman is manager and staff attorney of the Immigration Law Project at the Los Angeles LGBT Center. She has practiced removal defense in Chicago and San Francisco, and most recently at Community Legal Services in East Palo Alto. Her practice focuses on humanitarian and relief for asylum seekers and survivors of trafficking and removal proceedings before the USCIS. Tess attended law school at Loyola University School of Law, where she was also in private practice in Chicago and focused on removal defense and family-based immigration cases. Tess has worked at ICE detention centers around the US, including Dilley, Texas. Her most recent op-ed about the administration's attack on asylum seekers appears in The Hill. Bamby Salcedo is a national and internationally recognized Latina woman who received her master's degree in Latina studies from California State College in Los Angeles. Bamby is the president and CEO of TransLatin at Coalition, a national organization that focuses on addressing the issues of transgender Latinas in the United States. And Bamby is an innovative and organizer who created several organizations from ground up to serve the population. Her skill crosses borders and boundaries and works in the intersection of multiple communities as well as multiple issues. Bamby has served and participated in many local, national, and international organizations, and her work mediates intersections of race, gender, sexuality, age, social class, HIV status, and immigration status, and more. Cristina Velez is currently a senior staff attorney at the National Immigration Project of the National Lawyers Guild. Cristina provides technical assistance and training and participates in impact litigation, challenging systemic inequities and special attention to the intersection of immigration and criminal law. Previously, Cristina spent 10 years at the HIV Law Project in New York City, where she represented immigrants living with HIV or AIDS in a variety of immigration matters, including asylum, family-based immigration, and humanitarian relief for survivors of violence in the United States. Cristina graduated from Oberlin College and Cornell Law School. So many, many thanks to our panelists. And I would like now to turn to David to speak with us about the many changes that have happened. Probably no field of law has encountered more changes in the last few years through this administration than any other practice. So David, I turn to you as our expert and look forward to hearing you discuss these.
Thanks very much, Margaret, and it's such a pleasure to be here with everyone and all my other esteemed panelists. So I'll be speaking a little bit about the sort of background, to give sort of a background about an introduction to some of the current issues in immigration law. I imagine that many of our participants are attorneys, but I know that some folks may not be as familiar with the immigration system. So I'll try to give a little bit of an overview of that. And then we'll also sort of speak, as Margaret mentioned, about some of the most recent challenges that we've been facing sort of systemically as immigration attorneys. And then, those issues as they impact HIV positive individuals more specifically. So to start at sort of a 30,000 foot view of the American immigration system, there's only certain pathways to receive immigration status here in the United States. There's no sort of general way that somebody who's here undocumented or here without status can just apply to become a green card holder. There needs to be a specifically enumerated basis to become a sort of a pathway towards green card status that's already established by law. And so the two sort of largest ways or most common ways that people become permanent residents here in the US are through employment-based petitions and family-based petitions. So employment-based are things that you might have heard of in the news, like the H-1B program, or other sort of ways that people can, their employers will help sponsor them for some kind of immigration status here in the United States. The other very common pathway to immigration status is through a family-based petition. So if somebody here in the US who already has a green card or as a US citizen can apply for certain family members to come join them in the United States based on many there's different restrictions and procedures, but generally that's another big way that people can get status here in the United States. The third sort of overall bucket of ways that people can get immigration status here are through humanitarian forms of immigration relief. And we're going to be focusing a little bit more today on the humanitarian forms of immigration relief. And so these include protections for people that would otherwise not be eligible for immigration status that might have suffered some sort of hardship either here in the United States or in their home country, where the United States should be extending sort of the benefits of immigration status to folks in these different situations. So this includes asylum status and refugee status, which we'll be discussing in more detail. Forms of relief called U and T visas, that's for people who are victims of crime here in the United States and have been helpful to law enforcement, or T visas are for folks who've been victims of trafficking and are present in the United States on account of that trafficking. There's also specialized protections for undocumented individuals that was contained in the Violence Against Women Act and others. That's just sort of an example of some of the humanitarian forms of immigration relief. It's also important to mention that in order to be eligible for immigration status here in the United States, you have to go through a process of admission to the United States. You have to be admissible in order to gain status. And so there's many different grounds through which one may or may not be admissible to the United States. There's a lot of criminal bars to gaining immigration status. If you've engaged in fraud, if you entered without inspection, or entered without, a visa, for instance, all of those things can be barriers to gaining immigration status here in the United States. And thinking specifically about the HIV context, our other panelists will go into this in much more detail, but there are enumerated health-related grounds of inadmissibility. If people have communicable diseases, they might be excludable from the United States. And so an HIV status has been implicated in that in different ways historically in the US. The next thing I wanted to talk about briefly is the structure of the immigration system, to get a sense of who the major players are. The Constitution gives Congress the power to establish a uniform rule of naturalization. So most of the immigration laws are contained in the Immigration and Nationality Act, which was initially passed in 1952 and then updated in 1965, and that has been amended many times by different pieces of legislation since. And that's all contained in the US Code at Title 8. So if any of us refer to the INA, we're talking about the Immigration and Nationality Act, which is sort of the Bible for immigration law. However, a lot of immigration law ends up in the purview of the executive branch. because there's multiple executive branch agencies that have a great deal of power over the ability to gain immigration status. So the three sort of main branches are the Department of State, the Department of Homeland Security, and the Department of Justice. The Department of State is involved when someone is seeking a visa to enter the United States. They have to go through a consulate abroad, or sometimes there's something called consular processing for certain kinds of other family petitions and things like that. So the initial point of contact might be at the consulate or embassy abroad. Domestically, the Department of Homeland Security is a major player, both in terms of the benefits arm of immigration and then also in terms of the enforcement arm. So if someone is seeking to gain an immigration benefit here in the US, many times they're filing an application with US Citizenship and Immigration Services, which is a major branch of the Department of Homeland Security. And that includes agencies such as the asylum offices, for instance. DHS also contains the two largest immigration enforcement arms, and that's Customs and Border Protection, better known as CBP, which is in charge of enforcement at points of entry and along the borders, so like at airports, along the southwest border, along the border with Canada, and then Immigration and Customs Enforcement, which is for internal enforcement within the United States. And so that's things like enforcement and removal operations, and then also Homeland Security investigations. Last, there's the Department of Justice, and that's one of the other adjudication branches. If someone is in immigration removal proceedings, they're appearing before immigration judges that are part of the Executive Office for Immigration Review. And the appeals board, the sort of first appellate board for immigration judge decisions, is also contained within EOR, and that's known as the Board of Immigration Appeals. And so all of these executive branch agencies have an enormous amount of power, and sort of thinking about the dynamics of immigration, whoever is president, whoever controls the executive branch, has an extraordinary amount of power and discretion over the implementation of immigration rules. Of course, the federal courts have the power to review decisions made by the executive branch. However, because we're talking about executive branch agencies, and agencies are given an extraordinary amount of discretion in creating and interpreting the rules that apply to their agency, they're given Chevron deference by the courts. So when DHS makes a rule implementing the INA, and then also sort of creates the procedure for implementing that rule, ordinarily when it goes to federal court, speaking very broadly, whatever the agency's decided is given extraordinary amount of deference by the courts. And so thinking about this dynamic moving forward, the executive branch has an extraordinary amount of power within the immigration system. So I wanted to look a little bit more closely in the humanitarian sphere, looking at asylum, refugee, and fear-based immigration relief. And so the major sources of law for asylum and refugee status come in domestic law from the Refugee Act of 1980. And part of what that was implementing was a much larger human rights instrument, which was the United Nations Convention and Protocol relating to the status of refugees. And so when the US is implementing asylum and refugee law, it's actually part of a much broader body of law that comes from international law. And so immigration, or better put, asylum and refugee adjudications in the US actually bear a lot of resemblance to similar adjudications done by other countries. There's also an international human rights body called the UN Convention Against Torture, which I'll talk more about in a second. A question about nomenclature. A lot of times I think people use the term asylum and refugee interchangeably, but actually in US law, there is a distinction. Both asylum and refugee adjudications actually are looking at similar questions, the definition of a refugee, which I'll talk about in a moment, but refugee adjudications happen abroad. And so people who are brought into the US as refugees have already been adjudicated and found to be refugees while they're living abroad, usually in refugee camps, and they're brought in as part of the refugee resettlement program. Whereas asylum seekers are people who have to be physically present on US soil in order to apply for asylum and then have their case adjudicated here domestically. However, in both cases, the question is whether or not an asylee or refugee meets the definition of a refugee. And so that's the sort of lengthy paragraph right here. Any person who's outside their country of nationality or country of habitual residence and who is unable or unwilling to return to and unable or unwilling to avail themselves of the protection of their country because they've been persecuted or have a well-founded fear of persecution. This persecution is on account of race, religion, nationality, membership in a particular social group, or political opinion. And in the next couple of slides, we're going to go much more in depth into what all of those things mean and how these adjudications impact people with HIV and also, LGBTQ folks. It's important to note that asylum and refugee protection is not given just for anyone who's fleeing violence, war, issues in their home country. One of the things that's important to note now is that it's actually a fairly narrow definition because each of these things that I bolded have a very specific definition under the law and exclude an extraordinary amount of situations. So many people who might be fleeing situations that are horrible in their home country still wouldn't, under US and international law, qualify to be asylees or refugees. I also just wanted to briefly mention the Convention Against Torture. Sometimes it's implicated if somebody is not eligible for asylum or refugee status because they're barred by some sort of criminal issue or other kinds of issues. The US still cannot deport somebody who is afraid of being tortured or to a country where they have a fear of being tortured. And so that can often implicate people who are HIV positive who may not be eligible for asylum or refugee status, but still fear that they might be tortured in their home country by the government or at the acquiescence of their government. So they might still be eligible for some sort of relief under the Convention Against Torture. So that's sort of a catch-all provision. So I want to go briefly through the asylum eligibility requirements because this is a very complicated body of law and this could be its own training on its own. But there's a couple of kind of important things to note here. First is that in order to be eligible for asylum here in the US, you must file within 1 year of entering the United States. This is actually a major impediment to folks because people often enter the United States and have absolutely no idea what the rules are. Unsurprisingly, given that they may not speak the language, they might not be familiar with our legal customs here. And so this is a major impediment if they have not filed their application with the government within 1 year of entry. The next question is whether or not they've already been persecuted or they fear persecution in their home country. If somebody's already been harmed in their home country, then we tend to assume that they would have a fear of persecution if they return. But it's not necessary to show that you've already been harmed in your home country. One can gain asylum by showing that they have a well-founded fear of persecution, which has been found by the Supreme Court to be as little as a 1 in 10 chance of persecution. However, persecution has a very specific legal definition, which is to say persecution doesn't encompass all forms of harm that somebody could fear. Persecution is usually referring to some fairly serious forms of harm, often some sort of physical harm or economic harm that sort of affects one's fundamental livelihood. So, there's case law that holds that discrimination or harassment often don't rise to the level of persecution. Persecution is a very high level of harm that someone must fear or have already suffered. The persecution also needs to have happened either at the hands of government actors or by private actors that the government is unable or unwilling to control. And this can absolutely implicate HIV positive individuals. Often people are fleeing from a situation where they might not have been harmed by the government, but maybe rule of law is very tenuous in their home country and their government does not protect them against private individuals, or the government may be itself involved in harming such people. And as I mentioned, you have to have been harmed for a specific reason under US law. So generalized strife, violence, famine, poverty are not grounds for asylum. It's actually almost akin in some ways to civil rights law. You have to have been a member of a sort of protected class of people. And so there are 5 enumerated grounds that discuss what those protected classes are. It's one's race, their religion, their nationality, their political opinion, or their membership in a particular social group, which is the sort of catch-all provision that can protect people like LGBTQ folks, people living with HIV, or other types of configurations. But it's generally, particular vulnerable groups within that country and according to the customs of that country. There's also this term called humanitarian asylum, because sometimes somebody might have been fleeing a situation that no longer exists in their home country, but they still may be eligible for asylum, even if they do not fear returning to that country now. A sort of classic example of this might be someone who was tortured as a member of an opposition party, but since they came to the United States, their party may have taken control of the government and now no longer they're afraid of their government. But if what they suffered in the past was so serious and so severe that it would be against humanitarian norms to return them to their home country, then they may still win asylum based on the severity of their past persecution. Or if they would suffer some other serious harm upon return to their home country, they may still win asylum. And I know that other panelists are going to be talking a little bit more about this later in the presentation. Another way in which HIV status may come up during the course of an asylum adjudication is in exceptions to the 1-year filing deadline. Often people may become HIV positive within the United States or may discover their HIV status once they're here in the United States. That's a frequent exception or a possible exception to the 1-year filing deadline for people who have an HIV diagnosis. And I know other panelists will get a little bit more into representing people who are applying for asylum who are HIV positive and sort of some of the practice pointers that people may encounter. So now I wanted to briefly touch on some of the recent trends in immigration law and policy that are affecting, frankly, all immigrants and advocates, but may sort of impact people living with HIV disproportionately. And there's sort of maybe 5 general trends that we're seeing over the last 3 or 4 years. The first is barriers to entering the United States, making it more difficult for people to physically get here and have access to the United States. Another is increased internal enforcement. There's been a great deal more ICE raids and ICE activity within the United States under this administration. I think a really unique focus on restricting humanitarian benefits, often in periods where there was more of an emphasis on enforcement as opposed to immigration benefits. There was still not a sense that the government was seeking to restrict things like asylum or U visas, or sort of this group of people that was seen as sort of especially vulnerable even within sort of the immigrant population. While under this administration, there's almost been this laser focus on restricting things like asylum, refugees, and other sort of humanitarian forms of relief that had been sort of ignored or passed over by other administrations that might have been more enforcement minded. This administration has also used regulatory and rulemaking power to very specifically narrow eligibility for immigration relief, but then also to change the rules around how people can apply for immigration benefits and relief to make it much more difficult to do so in ways that are often sort of hidden from public view because it seems so technical or so in the weeds that people don't notice. And then the last I would say is that there's just been a real change in the public discourse around immigration. I think historically, even if there were administrations that were more enforcement minded, there was still sort of this general tone that immigration as sort of a concept was something that should be celebrated. We're a nation of immigrants. We're changing the rules a little bit, but still generally, immigration is something that should be celebrated and encouraged. I think now there's a real sense of demonization around the very concept of immigration, and things that have been time-honored immigration patterns like family migration has now called chain migration. Something family petitions have existed for years and years and years, but now it's being demonized as something called chain migration. Something that's evil and scary. That really has just been a facet of how immigration practice has been for decades. And so looking a little bit more closely at each of these things in turn, some of the barriers to entering the United States are very well known. For instance, the Muslim travel ban, which was a very early issue in the Trump administration, where people from enumerated countries were very explicitly forbidden from entering the United States. And that was sort of a return to the very exclusionary immigration policies from the early 20th century, where there used to be quotas from different countries and certain, races and regions were explicitly excluded from immigration benefits. And all of that was sort of overturned in 1965. There was sort of this return to, a very, frankly, nativist immigration system. There's also been travel restrictions implemented because of the COVID crisis. And there have been some very specific restrictions on people applying for asylum under the migrant protection protocols. Now people who are crossing across the Southwest border are generally being put into Mexico to await their immigration adjudications here in the United States, which is a completely new phenomenon. or also a ban on people receiving asylum if they've transited through other countries in order to get to the United States. And then, even people who are applying for asylum in the US, if they pass through other countries, they're being returned to those countries to apply for asylum in those countries, like Honduras, Guatemala, even if those countries themselves are big sending countries because they have problems with internal strife, danger, and persecution themselves. And so I just wanted to show this graph about refugee resettlement. Historically, there's a cap every year on how many people can be resettled in the United States that have already been found to be refugees. Historically, the refugee ceiling was quite high. I mean, in 1980, it was 232,000 people, but then it held steady at about 70,000 people. And so the US was allowed to resettle up to that number. But recently, starting in fiscal year 2017, the number has plummeted, and then the number of people who have even been admitted under those caps has plummeted. And so the US is taking fewer refugees now than ever before. And I just wanted to mention.
Oh, sorry.
Sure. And we'll talk much more about this in depth, but I just wanted to mention one or two other serious changes recently that are impacting our clients enormously. The first is the public charge doctrine. And so in order for somebody to be admissible to the United States as a permanent resident, they need to show that they would not become a public charge, they would not become dependent on the United States government. And there were recent regulations to change how that public charge determination was made to make it much more difficult to show that you would not become a public charge. And that was done by regulation, and there's been a lot of litigation in the courts around the implementation of that regulation. And then sort of within the immigration removal system, there have been an enormous amount of cases published by the Board of Immigration Appeals and by the Attorney General himself, trying to restrict eligibility for certain kinds of immigration benefits, specifically asylum, but a lot of criminal immigration issues as well. There's just been an extraordinary amount of cases published by the Board of Immigration Appeals and by the Attorney General themselves, trying to restrict eligibility for immigration benefits. And then there's an extraordinary amount of procedural hurdles. There's been a lot of changes in how applications are being processed, the rules about how you can submit applications, changes in practice in immigration court, changes in processing priorities by USCIS. I mean, I could talk for hours about this, but there have been numerous ways in which there's been little tweaks sort of invisible to the public eye, but that make immigrant advocates' lives that much more difficult, and by extension, the lives of immigrants who are applying for benefits that much more difficult. And so we'll talk a little bit now more in depth about the changes that are particularly impacting HIV positive people, and then also sort of the kinds of issues that impact that population specifically.
Sorry I interrupted you. Thank you for that most informative presentation. And for those of you who are writing questions, Bamby Salcedo is now going to present her work to us. And then we will take 10 minutes after Bamby presents to take some questions for both David and Bamby. So thank you for joining us, Bamby.
Of course, thank you. Bueno, primero que nada, yo quiero darle gracias a mi poder superior por darme la oportunidad de estar aquí con ustedes, y también quiero honrar la presencia de las personas que nos acompañan hoy en día. I know that it was probably hard for some of you to understand what I just said, but it is a customary thing that I honor my creator and my higher power for giving me the opportunity to be here with all of you, for giving me the opportunity to breathe one more day. And I also want to honor the beautiful and amazing people who are joining us today. My name is Bamby Salcedo, and I am a very privileged trans-Latina mujer inmigrante indocumentada who has the privilege to lead a national advocacy organization that also provides direct, supportive, and life-saving services in Los Angeles to trans and gender non-conforming people. We're actually the first TransLatin organization in Los Angeles that is doing this work specifically to support and uplift the life and experiences of trans and gender non-conforming people. So I am very honored to be here with you, and thank you so much for the organizers of this panel for giving me the opportunity to share space with all of you and share with you my experience, strength, and hope in the work that we do to uplift the lives of trans people, but even more specifically, the lives of trans Latina or trans individuals actually who are detained in immigration detention. Since the inception of our organization in 2009, this is the very reason why we exist. Back in 2009, there were two amazing, prominent translate organizations, national translate organizations that were doing amazing work, but unfortunately were not including the specific needs and issues of trans Latina immigrant women at the time. And a group of us got together and started a conversation for us to figure out what is it that we were going to do in order for us to have a voice. And our organization started as, volunteer run organization. Part of the work that we have been doing since the beginning of the organization is, do visitations and immigration detention. Being that we're based in Los Angeles, as you may know, there's a couple of immigration detention centers, one in San Diego, previously one in Santa Ana and in Delano. So those are the closest ones that are to where we are. And we have always been supporting trans women who have been inside immigration detention or detained, seeking refuge or asylum. Um, we have supported them with commissary money for them to call whoever, even if it's a lawyer, for them to get stamps or, even a cup of noodles, right? Because a cup of noodles in immigration detention is luxury. So we have been doing that. And then obviously as the work of organization progressed, and also through the advocacy and the advocacy that we have done really to uplift the human treatment that trans women continue to experience in immigration detention. I myself was in immigration detention um, back when the San Pedro Detention Center, which was one of the worst and it's one of the reasons why they closed it. I was detained at that immigration detention. I was brutally attacked and had my nose broken while I was inside. And so because of the advocacy and my personal experiences, and as the leader of an organization, um, I wanted to make sure that trans women who are going through immigration proceedings, get some kind of support, right? Because oftentimes when we travel to come to the United States to try to find the American dream, right? We also often find the American nightmare. And so, and that nightmare really begins in immigration detention, right? And now, as it was mentioned before, right, with the closure of the border, there are a bunch of trans people who are stuck in and the different points of the border, but even more specifically in Tijuana. And so, again, the work that we do, it's specifically to support trans people who are in inside immigration detention. We currently have two rapid response teams, one in New Mexico and one in Aurora, Colorado, where now is the trans spot. So some of you may know that in 2015, again, because of the advocacy that we have been doing along with other amazing groups and organizations, ICE, in order to, I guess, address the inhumane treatment that trans women were experiencing, created this transgender pod. And even though they did that, the experiences of trans women obviously continue to be the same, especially when it comes to, to those individuals who are HIV positive or need medication. Um, as you may know, there have been actually in the last couple of years, there have been a couple of murders, but even the murders of trans women go back to, even before, right? Like some of you may remember the case of Victoria Arellano in 2006, who also perished in immigration detention due to the lack of support with, her medication. And more recently, um, the death of Joanna, and for not being able to obviously have access to medications. And so, so this is our recurring issue that we obviously continue to work to make sure that we address. And through the rapid response teams that we have, we also, we pick up people when they're getting out. We help find sponsors for them, even legal services. We then, when they get out, we work with other organizations to send them to whatever they need to go to and connect them to services. And here in Los Angeles, we do have a reentry program that supports trans people who are getting released from jail, prison, or immigration detention. And then through that, in Los Angeles, we have been able to build a multiplicity of services, which includes workforce development, and we have an anti-violence project. We give food every day. We have clothes. We give hygiene kits. We have legal services specifically for focusing on immigration. And we also do policy. So we also have a transitional housing program, and within that program, we have a room that we have converted into um, emergency housing to really support those individuals who need emergency housing. And so, we continue to do the work that needs to be done. I do want to say, though, that some individuals and organizations have categorized the work that we do as radical, but that's what we have to do as trans people. Um, as you may know, the violence, both institutional and interpersonal violence that we experience within our society, is some of the things that we fight to eradicate. And to us, and the work that we do, although the work that we do is informed by our community, what we make sure to do is to not just bring visibility to the issues, but also to really make sure that we create the changes that need to happen within our society in order for us to have better quality of life, and for us to to continue to thrive and succeed in this world. So I just want to just give you that for right now. I don't know if you have any questions. Obviously, I can talk a lot more about a multiplicity of different things. But unfortunately, I do want to excuse myself because I do have another commitment. And I, along with the organizers of this event, we wanted to make sure that we have some time for people to ask some questions. So again, thank you so much to all of you for tuning in. And thank you so much for the organizers to inviting me to be part of this amazing panel.
Thank you, Bamby, and thank you for your groundbreaking and essential work. As Bamby mentioned, she does need to leave us by 11 Eastern time, by 2 Eastern time. So we will take questions now for both David and Bamby. And here's one question that has come in for David. How do the barriers intersect? For example, how do metering and MPP apply, as they seem to be inconsistent programs?
Sure. Just to give a little bit of context. So on the southwest border, what I had mentioned, the migrant protection protocols make it so that people who ordinarily would have been able to enter the United States, apply for asylum, and remain in the United States during the pendency of their asylum proceedings are now being returned to Mexico to essentially shanty towns along the southwest border on the Mexican side to wait for them to be able to come in for an immigration hearing to establish whether or not they can enter the United States. Metering is the practice at ports of entry along the southwest border, where CBP only will allow several people a day, if they're allowing anyone in, into the United States to pursue their claim. I couldn't say exactly why some people are metered in and why some people are subject to MPP. I mean, I know that generally CBP officers do have the discretion to, for instance, parole people in if there's sort of medical emergency or some sort of humanitarian reason that someone should be considered to enter the United States. But it's often left to the discretion of the CBP officer who gets in, who gets out, and often CBP doesn't follow their own internal policies, and so you have folks who are attorneys or advocates who help escort people up to present themselves at CBP in order to be allowed in. But in terms of when someone's allowed to be metered and when someone is sort of sent back to Mexico to await their hearing, I can't speak specifically why CBP sometimes opts to do one or the other. I'm not sure if Tess or Cristina has any more insight than I do into that.
Thank you. Bamby, for referring to the detention centers, are there different problems, whether the person is transgender woman or transgender male, in terms of the responses of those administrating the detention center?
Well, I mean, we know that, trans people experience discrimination in most aspects of our lives. So that definitely happens. But I think what it's important to understand is that most trans people who are coming to this country to seek refuge and request asylum, they have a validity, right? Just for being trans, we are a constant targets of attacks, right? Not just in our countries, but even here. And so I think it's important to recognize that many members of the trans community, the language is different, for instance, in Latin America, right? And so when many members of our community are seeking asylum, for instance, and also oftentimes are not able to articulate their stories the way that they should. Many of their pleas or cases are not considered asylum, or or oftentimes immigration officers or even judges, right, think that because for instance, like in Mexico, right, that people are able to marry, like gay marriage is legal in Mexico, that the issues of violence towards trans people are not prevalent, which is not true, because Mexico is the third largest or the third country that portrays the most violence against LGBTQ people, right? And so there's a lot of education that needs to happen, but truly trans people continue to face I'm going to say discrimination in these issues. And also, there's a lot of biases that are portrayed, right, when all of this type of situations happen, and people's beliefs and all of this, they bring that with them, right? And so many people often think that we get what we get because of who we are, and if we weren't who we are, that we things that happen to us would not be happening, and so a lot of those things are blamed onto us, but in addition to that, I think part of what the system has done to not just members of our community, but just people in general, is that when because of the advocacy again, right, trans people are also being released, but they have their cases pending, and they are released to nothing really, right? And so it's hard for trans people to get out of the cycle of the criminalization process that we go through, right? You know, in order for us to survive, we have to engage in the street economy oftentimes. And because of that, we get arrested. And because of that, we ended up again in immigration detention. And so, you know, also the system has a lot to play with that. And so we need to find ways to find some type of support to support individuals who are getting released from immigration detention. But in this case, you know, I'm specifically talking about trans women, right? So that, you know, we get out of that cycle so that we can find ways for us to continue to thrive and to, you know, find paths for, yeah, for work, or like a pipeline for work. But we cannot get work if, one, we do not understand or cannot speak the language, if we have to acculturate to a new society, right? And also, you know, hard to navigate places that we don't know. You know, oftentimes people, trans people, when they come from their countries, they turn themselves in, and they have never been in the United States, right? And so it's super hard to navigate a new place when, you know, when you don't even have the resources that you need, like a social security number or any type of benefit, in order for someone to survive.
Thank you, Bamby. And thank you both for your presentations. And I know, Bamby, you'll need to leave. So I would like to now introduce Tess Feldman and Cristina Velez, who will speak with us about their practices and work with those seeking status in our country. So Tess and Cristina, I know you prefer a more conversational style of presenting, so I'll just turn it over to Tess and you can comment as you please.
Thank you. Sounds great.
Thanks, everyone. I want to also highlight that as the immigration attorney here at the Los Angeles LGBT Center, I have the privilege and honor of working with many clients who are served by Bamby and her team at the TransLatin Coalition. There's a wonderful population that we both get to serve here in LA. And so many of the clients that I get to work with in the courtroom are receiving support from Bamby and her team at the coalition. So it's great to see you on screen, Bamby, because we don't get to overlap in person, even though we're neighbors here in LA. So Cristina and I put our heads together to talk about lots of different issues that people with HIV status face as asylum seekers, and also our experiences working with a variety of different people facing different challenges in the immigration space that David so eloquently explained. And we also have some tips to share as practice pointers for practitioners along the way, based on our learned experience through the lived experience of our clients. So at the LGBT Center, we run a legal clinic, which used to be an open doorway for clients to come in and ask legal questions, but now, due to the COVID-19 climate, is a phone-based way for people to cold call with questions. And that is a great entry point for clients to come to us seeking full scope representation. So as the attorney at the center, I'm able to provide that representation to some of the most marginalized folk who might not find safe support in other places or with other attorneys, many of whom are clients that Bamby talked about. All of our clients are generally identify as part of a marginalized population and have a much harder time getting through the process because of that. But I also want to name today with this group that our clients are really strong. They're resilient, they're brilliant, they're powerful people, they're very educated. And I think when we talk about the way that the society globally and here in the United States marginalizes people, we often inadvertently take away a lot of power from them. So the clients who are in detention or successfully get out of detention as part of their asylum journey, who go through these horrible things, are survivors of the process itself, in addition to everything they've survived that helped them along the way of getting to the United States. And I just want to name that because we often focus on the challenges and the barriers and not the success stories. One of the clients that I've worked with that went through so much of what Bamby identified in ICE detention is a person with HIV status. She's an advocate from El Salvador. She does human rights work around the world. She traveled extensively and spoke with the United Nations as an activist before fleeing her country for her own safety and entering our immigration system. She was detained and she advocated for herself in English. She told the detention center that she had HIV, she needed medication. She knew what medication she needed, and she was denied that medication. So despite her best efforts and doing all the right things, she was incredibly sick in custody and fortunately was able to get out, and we just filed for her green card over the summer. So she should be getting good news in the mail, hopefully very soon. So the background that I just want to bring to what Cristina and I touch on is that while these are often folk who are negatively impacted or targeted by the system that's designed now to be more difficult for them, they're also strong and very successful, and we have great outcomes for these people because asylum seekers have legitimate claims, despite what we see the administration telling us and what the headlines say. These are folk who would much prefer, in my experience, to be home with their families and live safely and peacefully in the countries they're from, and only are here seeking asylum through the processes that David's explained because they don't have any other choice. So Cristina, I'll kick it over to you.
Hi, thank you so much, Tess, for that, that sort of introduction to our section. I also want to agree and underscore what you said about our clients being so resilient. In much of my work with clients living with immigrant clients living with HIV, I've found those clients to be almost uniformly better educated about their health needs and their treatment plans than really anyone else. Much better educated than maybe they are about the immigration system, which causes, I think, some of the barriers that we're going to talk a little bit more about together. And they've been negatively affected by some of the messaging in the immigration system that I think cause greater harm to them as a group in general. I wanted to sort of talk a little bit more about, I wanted to take a little bit of a step back and talk about how the intersection of HIV and immigration kind of began or was in place before 2010 when the HIV travel ban was lifted. So when I started working with the HIV Law Project in New York City, the HIV ban was still in place. That was 2008. The HIV ban had been instituted in around 1988 through some, I think, advocacy by Jesse Helms, who, for folks who don't know, was a sort of notoriously hateful and racist senator, and what his desire to prohibit people living with HIV from entering the United States and from being admitted to permanent resident status was really animated by his association of HIV with LGBT people and his dislike of that group of people. So that's where HIV was first sort of included in, or was first, the intersection between HIV and immigration sort of began. It was initially, there was no waiver for people who were considered inadmissible because of their HIV status. So for the first 2 years that there was an HIV ban, if you were HIV positive and you could not immigrate to the United States, there was nothing more that you could do. There was no way to overcome that ground of inadmissibility. And throughout the immigration law, as it stands, there are various waivers of inadmissibility that one can apply for if they have sort of a qualifying relative who is a US citizen or lawful permanent resident, or for people who have asylum, if there are sort of like, I forget what the exact terminology is, but if there's a strong humanitarian interest in them being admitted to the United States, which there of course usually is. But for the first 2 years of the HIV ban, there was no waiver. I met people when I started working there in 2008, and I continued meeting people who were caught in that gap in between 1988 and 1990 when the waiver was introduced, who were unable to immigrate or unable to get their green cards because of their HIV status. Even in 2010 in January, when the HIV ban was lifted, a lot of people had already been negatively impacted by it, regardless of the existence of the waiver. The waiver itself was pretty easy to get. Like, you just needed to show that you had a qualifying US citizen or LPR relative, and that you had access to private health insurance. And that required like a bunch of like very finely timed choreography in order for people to have the right documentation to be able to access private health insurance and show that they could qualify for the waiver. That affected mostly people who were applying for immigration status based on family relationships. And we got a lot of questions when I went with couples who were heterosexual couples at that moment in time. Although I think before DOMA was invalidated in 2013, you would see they sort of started to accept, I think, trans couples as well. But what I'm trying to say is that the encounters that we would have with USCIS really ranged from people who, from dealing with officers who are incredibly like sympathetic and maybe you could tell had some kind of existing knowledge of what they were experiencing as people who are living with HIV. Other times you'd encounter USCIS officers who could not understand for the life of them why we often had a lot of mixed status couples, I would say, where one of the spouses was not HIV positive. And the USCIS officers at times, they seem to have lacked any kind of sort of like cultural competency training with regard to HIV in particular. And they, would say sometimes very insensitive and offensive things about the couple. They would ask questions about whether the non-HIV positive member of the couple understood the risk that they were taking, things like that. So this messaging that I think is really reflected and encapsulated in the HIV travel ban, and in a lot of the sort of stigma and discrimination that we've seen throughout society, it enacts on individuals applying for immigration status in these ways. And they're very often at the mercy of the immigration system when they are applying for an immigration benefit, and makes them very vulnerable. So I wanted to just sort of like give that little bit of backdrop. There's also, I think, another feature of the sort of ongoing effect of the HIV travel ban is that there is a huge inconsistency in how people with HIV were treated under the immigration law at that time. There was this travel ban, you needed a waiver. People sort of understood that throughout the community that if you were HIV positive, like immigration didn't want you. That was sort of the broad understanding of how immigration, the immigration system would treat people with HIV. However, if you had an HIV diagnosis, could help someone overcome the 1-year filing deadline that Dave talked about earlier. It's considered a change of personal circumstances that can trigger sort of like new eligibility for relief. So of course, a lot of people who were not already connected to care and services would have no reason to understand that that was the case. And so they would continue to live sort of like underground somewhat and like under the radar, I would say, and try to avoid any contact with the immigration system whatsoever, which often led them to continue living in difficult circumstances and be vulnerable to contact with law enforcement, et cetera. So that's like sort of like the backdrop that I entered this work in. So I kind of want to turn it back to Tess now, and maybe because we talked earlier about some ways that she still sees some of these sort of attitudes and misconceptions continue to manifest.
Thanks, Cristina. If anyone is curious to learn more about this waiver that was part of an immigration application for someone who had HIV status about or over 10 years ago, you can Google it and see it online. And I think it still exists on the USCIS website because the continued stigma and challenge from that ban exists in the community in present day. That's been the lived experience of my clients, that every single, in my experience in my legal practice, every single person I've worked with who has HIV status or AIDS assumes they are ineligible to proceed in their case because of that status. The impact of that policy has carried over now 10 years in a very educated and informed, empowered community who remember or know someone who is ineligible or their status was somehow more difficult to obtain only because of their HIV status. So I know I have a lot of, we have educating to do in the community to make sure people feel comfortable and safe coming forward if they have HIV status, to know that these benefits that exist, they have a right to apply for them, and their process should not be more difficult just because of their status. That should be long in the past. That should be something that went away when that ban and waiver ceased to be part of a case that someone would need to file. But I think I'll speak to my own experience, it's alive and well, that concern and that worry for people who have HIV status or AIDS. And I think what Cristina also was talking about brings up an opportunity for advocates, allies, community members, and attorneys to make sure we're educating our adjudicators. Cristina gave that example of a USCIS officer who was applying their own biases and misunderstanding of the disease to someone's relationship in a marriage-based case. And that's, I think, a very common thing where we see immigration judges bringing bias or misunderstanding or ignorance to an asylum case. I know that's something I see frequently. You know, David and Cristina, if you have an example or something to add to that, please jump in, because I know this is a challenge we're all seeing in the courtroom and in the asylum office. Even if someone has good intentions, I find myself continuously surprised by an adjudicator either asking a question that's really traumatizing or making an assumption about someone's LGBT identity as it relates to an HIV status. Or someone, you know, Cristina was sharing her work with HIV positive people that may have status related to drug use or may not identify as part of the LGBTQ community. We're talking about so many people who identify in so many different ways. It's, you know, I want to be very careful not to generalize, but as advocates or even as immigrants representing yourself in an interview or the courtroom, we have to remember to take that extra step to educate who we're talking to about someone's status or their identity as it relates to an asylum case.
I have actually one example that illustrates what you're talking about that is also another aspect of the sort of intersection of HIV and immigration. A few years back, I was in 2012 and 13, there were a couple of cases in which people who had received withholding of removal or asylum in California, who were also engaged in sex work and housing unstable and, you know, struggling with various different issues, were arrested and prosecuted for sex work with some kind of aggravated enhancement because of their HIV status, regardless of the fact that they had, previously, with their client, like potential clients, had, revealed their HIV status. And the judges, they were detained, and the judges in those cases found them to have been convicted of a dangerous crime, a particularly serious crime, and terminated their relief from removal, which they had won initially because of the tremendous harm that they suffered in their home countries. And so these people were set to be deported back to those countries. But the HIV Law Project and Lambda Legal, and I believe the HIV Center for Law and Policy, we intervened in those 3 cases, or those 2 cases, I think separately. I submitted an amicus brief with Lambda Legal in one of the cases, and the center in the other case, educating the judge and also DHS about the science of transmission and what it being HIV positive means now, and what participating in that kind of work means as far as dangerousness. And we were successful. DHS actually, at least in one of the cases, I'm not sure what they did in the other case, but in one of the cases, DHS actually withdrew their argument and consented to remand so that the client could be granted relief and be released from detention. But he had been detained for a year and had lost a lot of the opportunities that he was lined up for at the time that he went in. So it caused additional harm, but that was so important that we intervened at the BIA level. It did not wait until the case got up to the circuit court, but took that opportunity to really, put some science down on paper and make sure that the record was clear and accurate.
So thank you. I see David eager to jump in here. He's nodding his head as each of you was talking. And I wondered if you had any follow-up comments you wanted to make to what Cristina and Tess said before we get to questions.
I just wanted to raise a question about asylum eligibility. Thinking about HIV status as sort of one of the things that can make somebody eligible for asylum. A sort of troubling trend that I had seen in a few cases from Honduras was actually HIV positive Garifuna women, so Afro-Honduran women, were forcibly sterilized at public hospitals in Honduras, believing that they were going to receive some sort of reversible birth control procedure, had actually been forcibly sterilized without their knowledge or consent. And I had seen that as, maybe not a huge trend, but it is a noticeable trend among HIV positive people in Central America. I think particularly in Afro-Honduran populations who are already subject to a great deal of racism and discrimination already. And that was just sort of a trend that I noticed in New York because the Bronx has a very large Garifuna population specifically. But it often in a dynamic way is related to sort of other types of harm that people suffer. It sort of is like a source of intersectionality among other sorts of harm that people suffer.
Yes. Sorry, I just
jump right in, Cristina. Jump right in. And Tess, feel free to unmute.
Well, you may know that was a feature of one of my cases when I was at Queens Legal Services, which didn't make it into my 3-sentence bio, but I was there before coming to my current job, where I did learn a lot about the Garifuna community and that these kinds of things are happening. It's a community with high HIV prevalence and where a lot of cisgender women who have sex with men are subject to coercive sterilization and fertility procedures, not limited to people with HIV, but it definitely happens especially to people living with HIV. I would also say that in my last case, where I represented a real person, a live person, my client was from the Garifuna community in Honduras and was an activist. Her HIV really became a source of political identity for her, which I think it has also that effect for many other people around the world who live in places where they have to advocate strongly for better care, for better treatment, for anti-discrimination protections, and where there are NGOs that help to fund that kind of work by hiring local people, and then who also will do some public education about HIV transmission, which requires them to often talk about things that are considered taboo and threatening to the power structure, and they become targets because of that. And so I want everyone who's encountering clients who may be seeking asylum, who are HIV positive, to also ask them what kind of work and activities they engaged in their home countries that were related to that status.
And we have a question too, as to the sterilization. Our participant wants to know if you have any update on the Irwin Detention Center hysterectomy case.
I can take that, because my organization submitted a FOIA recently seeking additional information about fertility, like about treatments involving fertility procedures and gynecological procedures throughout the ICE detention system, where women, in places where women are held, where cisgender women are held and subject to these procedures. So we're waiting for a response on that. I know that the situation, there's a lot of information about the situation at Irwin in particular that is still coming out. I know Tina Vasquez from PRISM has been doing a lot of writing about the situation there. I would follow her. And also Project South has been sort of leading the whistleblowing, has been representing the whistleblower in that case. And so they would have also up-to-date information about the efforts to close Irwin. Irwin's still open though, as we're speaking right now.
I have a question for all of you. I know that with all of these changes, we heard about the elimination of gang violence and domestic and gender-based violence as a reason for status. And I wonder, the way I heard it, it sounded absolute. Are there any ways in which intimate partner violence can still be grounds for documentation?
I'll take this one.
Oh, good.
Well, and Dave will have a lot to say on this one too. My answer is yes. If someone has fled their country based on past persecution and fears future persecution based on who they are or a group they're a part of, they remain eligible for asylum. And I think recent litigation that we've seen over the last 3.5+ years has done a lot to try to remove those protections and bases for protection. But I don't think that is a reason to tell someone they don't qualify for asylum. Our clients are dynamic, and there is always so much more to someone's entire life story than just being part of one group that the administration has targeted to try to discredit or invalidate in some way. And so I feel very strongly that while recent case law has not been on our side in many ways and has targeted female survivors of domestic violence or intimate partner violence in relationships, in my experience as an attorney, that's rarely the only claim that someone has in their asylum case. And so our recommendation is always to get a free consultation with a trusted attorney. I'm sure the panelists can, I won't speak for my co-panelists, but we're always happy to refer people to organizations in their hometowns or nearby. And one of the great changes in remote work in the time of COVID-19 is that many agencies have opened their access and their procedures to be able to do consultations with people by phone. And so anybody with a question about whether they're eligible for asylum in light of recent cases should double check that, triple check that with a trusted licensed attorney. And there's a lot of wonderful people providing those consultations at agencies around the United States. So my answer is investigate and apply, because the law is constantly changing. And I think those of us who have practiced asylum law under the Trump administration are optimistic that things will get better and laws will be reversed. And we're hopeful that our immigration system will once again come from a place of inclusion and open doors to provide safety for people, even though that's not where we are right now.
Strongly on our wish list. David.
I mean, I feel very passionately about this because working with Central Americans for so many years, I mean, are in so many ways have been explicitly excluded from asylum protection. The kinds of issues that are plaguing Central America, often caused by US action in the 80s up through today, have been like so specifically excluded from asylum protection. I mean, I think historically thinking about domestic violence as a basis for asylum, the framing was that people who had suffered domestic violence were members of a particular social group. But I can at least say in the Second Circuit in New York, there's sort of an exciting new case development thinking about feminism as political opinion and sort of resistance to gender-based norms, patriarchy, machismo in various countries as a potential basis for asylum. So at the beginning of 2020, my former colleague presented a case at the Second Circuit, Hernandez-Chacon v. Barr, where a woman who had been assaulted by a gang member but had fought him off was then attacked and targeted by that gang member and other gang members who said that she must sort of submit to their sexual predations, and she fought them off and argued that her attempt to protect her bodily autonomy in the context of the country in question was a sort of slap in the face to the sort of machismo prevailing culture that gang members should dominate and as men should be submitted to, and she won at the Second Circuit. So there is sort of an exciting development of case law, sort of thinking to Tess's point of sort of flexible thinking about the different bases for asylum and sort of trying to turn over. And each asylum case is very fact specific and should be adjudicated in a fact specific way. And so whenever the government, the Attorney General in matter of AB tried to say, well, generally these cases shouldn't win, that's dicta. Every single asylum case, according to case law, must be viewed sort of in its own, according to its own internal coherence and according to the facts of that specific case. And so I encourage people to read that case and also to reach out to the Center for Gender and Refugee Studies at Hastings Law School, who are sort of experts in this field and really collate all of the different cases that are happening in that sphere.
Great, thank you. We have a question. Any thoughts or insight into how the Title 42 border closure order has impacted LGBTQ+ and our HIV asylum seekers?
I should know more about the Title 42. I think this is where folks are being excluded, or folks are being removed without any kind of process. Is that correct? Within 100 miles of the border. Tess, are you saying something? No, okay. We've just started looking into it. I can't say specifically how the LGBT /HIV positive community would be affected by that. I think everyone is affected negatively by that. I think there is, a tremendous problem of harm to people living with HIV and people who are gay and queer in detention, period. And whenever they're in custody of ICE, they're vulnerable to a very high degree of harm. And being prevented from making their claims is, I think, very dangerous.
Yeah, I agree with that, Cristina. The Title 42 border closures were implemented in April in the context of the travel related to COVID-19 border closures.
Okay, thank you.
And so Christina's right. I think if the borders were open to asylum seekers, this would have had a more dramatic impact in the communities that we serve and see. But because so much border policy is already designed and in place to exclude asylum seekers from entering and accessing the legal process, which they have a right to, as a practitioner, I haven't seen the impact because it's sort of a duplicative closure of a system that's been closed, just on a different basis. And anytime a border or, there's a travel ban or a border closure, it's going to disproportionately impact a marginalized population, which is oftentimes inclusive of the LGBTQ community or people with HIV status. It's estimated that up to 40% of the population worldwide identifies LGBTQIA in some way. And so if such a significant part of the population is going to be reflected in a group of people, they will be disproportionately impacted by any change designed to prevent them from accessing a process or procedure. So I can't speak to anybody that I've come in contact with impacted by the Title 42 closure, but I have no doubt that in coming years, we will see people who have been traumatized by this block, who make it through and have to deal with, their case in a posture reflective of what comes next for us.
Absolutely. I also just want to say one thing about, as far as COVID is related, my org we released that sort of practice alert about humanitarian asylum, which contains a sort of a prong for consideration for adjudicators to consider the other serious harm is the phrase against persons who qualify for asylum because of past persecution, but for whom DHS has successfully shown that they're no longer eligible for relief because of some kind of change in country conditions or some other reason, but they can make the request for the judge or adjudicator to consider granting their case anyway, because they would experience other serious harm in their countries of origin, which include consideration of the availability of medical treatment for HIV, as well as for any other condition, which I think right now you're seeing a lot of problems with treatment of COVID infection.
Thank you. And David, I know you had a comment here.
Yeah, just to follow up on what Tess and Cristina were saying. I mean, I think one of the reasons that the government implements these kinds of orders is so that advocates don't actually have insight into how people are being affected. It's like, it's externalizing all of these issues that ordinarily we would have had insight into. We would have been working with these people because they would have been able to enter the United States. But now you have this tens of thousands of people who are being literally prevented from entering the United States and are in shanty towns on the southwest border, where there is not a very robust, or there is a robust advocacy community, but it is under-resourced. And those practitioners like us who are, I'm in New York, I'm not in Matamoros. I don't have that kind of insight into the issues that are plaguing these clients because they're not allowed to enter the United States. And that's sort of part of it is able to go under the radar in many ways because you don't have as robust, resources for folks in that position and, as much public attention being paid to, the Mexican side of the border, where ordinarily all of those folks would be able to access the resources of organizations like mine and Cristina's and Tess's.
That's an important perspective to remember as we're hearing about these changes. I think we have time for one more question. What is the status of family detention centers in Texas and Pennsylvania? Are families being sent there? are the families subject to MPP. Would anyone like to take this?
If we're talking about Berks in Pennsylvania, it is still operating. I know they're still fighting to get people out. Some folks have been in there for a long time. As far as the other detention
Texas.
Texas. I'm not sure, maybe Dave, do you know what the current status is?
Not Dilly, I must say. I don't know if Tess has more insight.
MPP is a way to keep people outside of the United States and sort of very slowly piecemeal start their case in the United States while keeping people out. So I think generally, very generally speaking, families who would be subject to MPP are not being processed, paroled in, and detained inside the Dilley, South Texas Family Detention Center. That's my understanding. I recently was on a panel with one of their directors, the Dilley advocates, and they are, you know, such fearless warriors fighting those cases at the border with clients. But I don't think people are being paroled in and detained as family units at the same rate. But I can't speak to personal experience on that.
Well, thank you. And I want to thank all of you so much. This was most informative, and we appreciate the fact that you are all practicing in a very difficult area at this time. And may I applaud your perseverance. But also you gave us options and talked about ways in which some cases can still proceed. So thank you for that optimism also. And so I believe we've answered all the questions, and it's 2:30. And I want to say thank you to our participants. We look forward to having you join us at future programs. And again, thank you most of all to our panelists.
Thank you so much for having us.
You're welcome. Our pleasure.